What is an AVO? An apprehended violence order, or AVO, is an order made by the court to protect you from another person. You can take out an AVO if you are afraid that another person is going to intimidate, stalk, or be violent towards you. An AVO includes a list of things that a person cannot do. For example, it can include orders not to approach you, harass you, or go to your address. There are two types of AVO. An apprehended domestic violence order, or ADVO, protects you from people who you have or used to have a domestic relationship with. This includes family, housemates, partners, and sexual partners. This includes partners of the same sex or gender. An apprehended personal violence order, or APVO, protects you from people who you do not have a domestic relationship with, such as co-workers or neighbours. The applicant is a person applying for the order. This can be the police or it can be you. The person in need of protection, or PIN-OP, is the person who the order protects. The defendant is the person that the order is made against. How do I get an AVO? There are two ways to get an AVO. The first way is to contact the police and tell them that you are fearful of the other person and explain the reasons why. The police can apply for an AVO for you and appear on your behalf in court. If you are in immediate danger, the police have the power to make a provisional AVO, which means that the AVO takes effect as soon as the police gives a copy of the order to the defendant. The AVO is not final until the court makes a decision. The police have discretion whether to make an application for you and will not always assist with AVO applications. The second option is to contact the local court registry and ask to make a private application for an AVO. If you make a private application, you can represent yourself in court or get a lawyer to represent you. When the AVO is listed at the court for the first time, the court can make an interim order, which means the AVO takes effect on a temporary basis until the court makes a final decision. AVOs and the LGBTIQ+ community. LGBTIQ+ people often experience different and additional kinds of abuse and can face extra barriers to seeking support. It's important to know that there is always help available for you. You can apply for an AVO if someone is behaving in a way that makes you fear for your physical or mental safety. The other person does not have to be violent towards you. This could include threatening to out you to your workplace, friends or family, or disclosing your HIV status without your permission. Let's take a look at some common questions. What do I do if I'm an LGBTIQ+ person and the police do not want to help me? The police have discretion as to whether they apply for an AVO. However, they also have a duty to protect you. If the police don't want to make an AVO application on your behalf, it is important to be assertive and tell them clearly that you want an AVO. You might find it helpful to take a support person with you when speaking to police. It may be helpful to give the police a timeline of the events that have happened that have caused you to fear the other person. If you have text messages or emails that demonstrate the other person's behavior, it can be helpful to show them to police too. Make sure to take down the name of the person you speak to and the event number so you have a record of making a report, and the police can see this if you make another report in the future. You can also ask to speak to the Domestic Violence Liaison Officer or the Gay and Lesbian Liaison Officer. If they still refuse to help you, you should seek legal advice. If the police mishandle your case, you have a right to make a formal complaint. It's a good idea to get legal advice first. I've had a bad experience with the police before. What if I don't want to report the violence? It is important to know that the police have a duty to protect you. You should still report the violence to the police and make sure there is a record of you doing so. If you are nervous about talking to the police, you can take someone with you for support. What should I do if I have been named as a defendant on an AVO application, even though I am the one experiencing abuse? Sometimes the police make a mistake about who is a real victim of violence. This might happen after the police attend a domestic violence incident where they think you have been aggressive or violent to another person, even if this was in self-defense. Or if someone makes a false claim that you are being violent towards them. If this happens to you, it is important that you get legal advice. If the police are applying for an AVO against you, you can still ask them to apply for an AVO to protect you as a victim. This is called a cross application. If both orders are made, you will be the protected person on one AVO and the defendant on another. If you are named as a defendant on an AVO, you have four main options. If it is the first time that the AVO is listed in court, you can ask for an adjournment, a new date, to seek legal advice. We recommend you seek legal advice as soon as possible. The second option is to consent to an AVO. You can do this without admissions, which means you do not admit that you did anything wrong. If you consent, the final AVO will take effect that day and you must follow the terms of the AVO. It is very important that you get legal advice before consenting to an AVO, as there can be serious legal consequences if you breach it, even if you do so accidentally. The third option is to not consent to the AVO. If you do not consent and challenge the AVO, the matter will go to a hearing. You and the person in need of protection may both be asked to prepare written statements. The fourth option is to offer to make an undertaking to the court in exchange for the applicant withdrawing the AVO application. An undertaking is a formal promise to the court that you will not do certain things. This option is only suitable if the applicant agrees with your offer. What conditions are on an AVO? What does it do? All AVOs will always have the same minimum conditions. The defendant cannot assault, threaten, stalk, harass, or intimidate the protected person, destroy or damage any of their property, or harm their pets. These conditions also protect anyone that the protected person has a domestic relationship with, including children. Other conditions can be put on the AVO if the court thinks this is necessary to keep the protected person safe. The standard period for an AVO is 2 years. However, the court can make the order to last as long as they think it is necessary to protect the victim. Let's take a look at some common myths and misconceptions about AVOs. An AVO is a criminal matter and will go on my criminal record. An AVO is not the same as a criminal charge and will not appear on your criminal record. An AVO will appear on the police's database so the police can enforce it. But if you breach the conditions of the AVO, you may be charged with a criminal offence and could face strong penalties, including fines or jail time. If I am a protected person under an ADVO, the defendant can't live with me anymore and can't contact me. Whether the defendant can still live with you and contact you will depend on the ADVO conditions. It is possible to have an ADVO with only the minimum conditions, which allows you to live together. If I am the defendant to an AVO that says I can't contact the protected person, I can still talk to them if they contact me. Once an AVO is made, the defendant is responsible for making sure that they do not breach its conditions. If there is a no contact order in place, you must not speak to the protected person, even if they contact or approach you. A protected person cannot be charged with breaching an AVO. However, if you are a defendant to an AVO and you feel that the protected person is harassing you, you can contact the police.